Good morning. My name is Roy Culpeper. I chair the Group of 78. I'd like to welcome everyone to this webinar on economic sanctions, legal and policy implications. I'm in snowy Ottawa, where we had a record-breaking blizzard yesterday, notwithstanding which I'd like to offer a particularly warm welcome to our two distinguished guest speakers who will shortly be introduced by our moderator. I'm making these introductory remarks in the traditional unceded and unsurrendered territory of the Algonquin Anishinaabe people. The Algonquin peoples have lived on this land since time immemorial. We're grateful to have the opportunity to be present in this territory. This webinar is hosted by the Rideau Institute in cooperation with the Group of 78 and the Human Rights Research and Education Centre at the University of Ottawa. It will explore the legal and policy implications of non-UN authorized economic sanctions, a policy tool that is increasingly favored by Canada, other Western states, and regional organizations such as the EU and the African Union. Now I'm delighted to introduce our moderator, Peggy Mason, president of the Rideau Institute, who is well known to many of you. Peggy's career highlights diplomatic and specialist expertise in the field of international peace and security, with a particular emphasis on the United Nations, where she served as Canada's ambassador for disarmament from 1989 to 1995. Since 1996, Peggy has been involved in many aspects of UN peacekeeping training, including the development of groundbreaking UN principles on the disarmament, demobilization and reintegration of former fighters, the reform of UN arms embargoes, and the dramatic evolution of UN peacekeeping in the 21st century. Until 2014, when she became president of the Rideau Institute, she regularly brought the UN political diplomatic perspective to a range of NATO and EU training exercises to help prepare military commanders for complex multidisciplinary peace and crisis stabilization operations. Peggy, over to you.
Thank you, and welcome everyone. I am extremely pleased to be able to moderate this important and timely discussion. I want to get into that discussion with our two distinguished panelists as soon as possible, but would be remiss in not thanking our two co-hosts and partners in the Rideau Institute project on economic sanctions that led to the report by Professor Craig Martin, around which this webinar is centered. These co-sponsors are the Group of 78, and you have just been welcomed by the chair, Roy Culpeper, and the second co-sponsor and publishing partner is the University of Ottawa Human Rights Research and Education Centre, headed by John Packer. The financing for this project is from a bequest to the Rideau Institute Research Fund, which also enabled us to have the report expertly translated by U of O common law doctoral student Abu Bakr Dakuyo. I turn now to our two panelists. And I have to say, after that long intro of me, I am going to be blushingly brief with our two distinguished panelists so that we can get to the discussion. We have a lot of ground to cover. I'm comforted by the fact that the Eventbrite invitation included their bios, which I hope folks have had a chance to read. Craig Martin, author of the report on economic sanctions and a Canadian, is a professor of law at Washburn University School of Law in Kansas and co-director of the Washburn International and Comparative Law Center. He teaches public international law, the law of armed conflict, international human rights law, international climate change law, and both comparative and US constitutional law. And I wish we had him back in Canada. Clara Portela, speaking to us from Spain, is a professor of political science at the University of Valencia and an award-winning expert on EU sanctions. She also has a strong Canadian connection, having been a visiting professor at Carleton University and the University of Victoria. She recently co-edited a volume on multilateral sanctions with Professor Andrea Charon of the University of Manitoba, publication of which is forthcoming with McGill Queen's University Press. A word on the format. Each speaker will have opening comments of 10 minutes. I will then pose some questions to each of the panelists, but I encourage them to feel free to comment on a question posed to the other, as we would like to engender as much conversation between them as possible while still trying to cover a lot of ground. We will leave time at the end, hopefully at least 20 minutes, for audience questions, which you can put in the Q&A box during the discussion. All during the discussion, you can be putting your questions into the Q&A box. You'll also be able to see the chat function, although not use it. And panelists might refer to a document and put the link in the chat box, but they'll direct you if they do that. Okay, let's get started. Craig, you have the floor.
Well, thank you very much. And let me begin by thanking the Rideau Center and particularly Peggy Mason for initiating this entire project. And I'd like to also thank the co-hosts, the Center for Human Rights and Research and Education Center at the University of Ottawa and the Group of 78. And I'd also like to thank my co-panelist, Clara Portela, for being here all the way from Spain, even if only virtually. So we're here, of course, to discuss the law and policy implications of economic sanctions. And my own interest in this has been to look more specifically at the lawfulness of so-called autonomous or unilateral economic sanctions, because there's been an increasing appetite on the part of countries, particularly Western states, in response to any number of apparent transgressions to impose these autonomous or unilateral economic sanctions in response to, as I said, any number of transgressions from human rights violations, rampant corruption, infringements of sovereignty, or nuclear weapons proliferation. And indeed, many champions of the rule of law and of peaceful dispute resolution look to economic sanctions as one of the more effective and legitimate tools one of the alternatives to the use of force, indeed, to impose costs on states that are seen to be stepping out of line, so to speak. But there are increasing questions about the lawfulness of economic sanctions, at least in some of the forms that they take and some of the circumstances in which they are used. And indeed, increasing critiques that some forms of economic sanctions are causing significant humanitarian suffering among the population of the target states, as well as violating the due process rights and other individual human rights of the individuals who are targeted by sanctions. And so there's a potential irony here that these policy tools that are employed for purposes of trying to enforce human rights and trying to enforce the international rule of law could end up actually undermining international rule of law and causing greater humanitarian harm than the international law violations that the sanctions are trying to address. So in short, these questions regarding the lawfulness of economic sanctions are, I think, very important. And this focus on economic sanctions is really quite timely. So in this very short introduction, in order to get the conversation that follows started, I think I might just begin by clarifying some terms and sketching out some of the basic legal framework that could guide our discussion. So we begin with economic sanctions themselves. There are some basic concepts and terminology relating to economic sanctions that we need to get clear. Generally, we're talking about, in terms of the forms that economic sanctions take, first, trade measures, right? So these are the imposing of prohibitions on trade, whether it's on specific sectors like arms and armaments, or total and comprehensive embargoes. So think of the embargo on Cuba. It can also include the imposing of tariffs, punitive tariffs on trade with the target state, on imports, exports. A second form of sanction are financial measures. So that is the placing of legal prohibitions on the execution of financial transactions with persons or entities in the target state or the target state itself, and or by freezing the assets of the target state or its nationals and national entities. And then a final or third form of typical economic sanction are in the form of travel restrictions. These can take the form of complete travel bans, think of the Trump bans at the early part of his administration, or targeted individual visa restrictions. Now, sanctions also differ in terms of the target of sanctions. So there's the state-oriented sanctions, trade embargoes and trade restrictions, of course, are imposed on the state itself. Again, think Cuba, Iran, Venezuela, and typically these are on the target state itself. But increasingly, we're seeing the use of what are called targeted or smart sanctions. These are aimed at individuals or sometimes corporate entities, typically to bring pressure to bear on the government of the target state. So an example of this would be the Magnitsky laws, sanctions against oligarchs and other influential persons in Russia to force Russia to comply with its human rights obligations. And finally, we have secondary sanctions, sanctions imposed on states or individuals or entities of states that are other than the targeted state. So an example of this would be the imposition of sanctions that force European companies to forego any transactions or trade with Iran, or sanctions against another state in order to force it to stop engaging in trade with Iran. Now, these obviously raise questions about the unlawful extraterritorial application of law. Canadians, of course, who observed the saga around the attempted extradition of the executive of Huawei to the United States to face prosecution for evasion of Iran sanctions, know this all too well. Now, finally, we can distinguish among sanctions based on the form of legal authority. At the very top of the hierarchy, we have UN authorized sanctions. These are sanctions that are authorized by the UN Security Council pursuant to powers provided to it in the United Nations Charter. Below that, there are sanctions that are authorized by international organizations, such as regional organizations like the European Union, the Organization of American States, African Union, ECOWAS, and so forth. And then at the bottom are what we call unilateral or autonomous sanctions. These are sanctions that are not authorized by any international entity. They do not depend upon or have any authority as a matter of international law, but are simply imposed by states on the basis of their domestic law. So which sanctions are problematic from a legal perspective? In terms of authority, the questions regarding legality are primarily focused on these autonomous or unilateral sanctions. And in terms of the form of sanctions, the focus tends to be on targeted and secondary sanctions. That is, sanctions targeting individuals or entities, and sanctions that are targeting other than the target state. As well, there are the kinds of comprehensive state-centered embargoes that rise to the level of threatening the food security and health of the populations of the target states. So what are the legal objections or the bases in international law for suggesting that some kinds of sanctions might be unlawful? What are the legal objections, so to speak? I'm just going to flag a few here so that we can get into them in the course of our discussion. The first is non-intervention. Right? This is the idea that economic sanctions constitute coercive intervention in the domestic affairs of the target state in violation of the principle of non-intervention in international law. Now, it's unlawful for states to intervene in domestic policy of the state in a manner that is coercive, that leaves the government of the state with little choice. Sanctions, of course, are by definition trying to force governments to change their behavior or policy. That's the very point of sanctions. And so it's argued by some that some forms of economic sanctions thereby constitute this form of coercive measure and therefore are instances of unlawful intervention. A second objection relates to the extraterritorial exercise of jurisdiction. Here, the idea is that sanctions, particularly secondary sanctions and secondary targeted sanctions, comprise an extraterritorial exercise of jurisdiction in violation of the principles of international law that limit such extraterritorial exercise of jurisdiction. Again, the basic idea in international law is that there are limits on applying a state's laws to non-national persons and entities for conduct outside of the territory of the state. So, purporting to apply one's laws against a German company for dealing with Iran arguably constitutes a violation of this principle unless it can satisfy certain exceptions. And the argument here is that secondary and targeted economic sanctions rarely can satisfy these exceptions. A third objection, which I flagged at the outset, lie in human rights law. The arguments here are complicated due to disagreements regarding the extraterritorial effect of human rights obligations. In other words, do Canadian human rights obligations under international human rights law extend to the people of Venezuela, for example? But at a minimum, there are arguments that states cannot impose sanctions that threaten the food security and health of the population of the target state. And the reality is that comprehensive sanctions regimes do so. There's evidence, for example, that the United States sanctions on Iran have caused deaths and greater illness in Iran during the pandemic, to cite just a recent example. And the Exhibit A for this argument, of course, are the sanctions against Iraq in the 1990s, which are thought to have caused tens, if not hundreds of thousands of deaths in Iraq. There are increasingly clear obligations now to include humanitarian exceptions for food and medicine in sanctions regimes. And this gives strength to the argument that there are indeed human rights obligations. But there's also empirical evidence that these exceptions do not operate well, and thus sanctions continue to cause humanitarian suffering in the target states. In addition to these broad humanitarian concerns, there are arguments that targeted sanctions, which typically target individuals, may violate the due process rights and other individual human rights of those individuals themselves. For one thing, if you're put on the sanctions list, on a designated list, there's often inadequate procedures in place to challenge that designation and to get yourself removed from the list. And we'll talk about that today, I'm sure, in the context of the European Union's sanctions regime, which offers greater protections than most. And then the final source of objection is international trade and investment and finance law. Now, these arguments are quite complicated and fact-specific, but the reality is that most forms of economic sanctions are going to violate principles of international trade law and potentially international investment and international finance law, unless they can meet certain specific exceptions. And the argument here is that usually economic sanctions are going to fail to satisfy those exceptions. So this just sketches out the framework for our discussion. Perhaps I should just conclude by emphasizing that the international law that relates to many of these issues is rather unsettled. In other words, and for example, the law on coercion and unlawful intervention, which suggests that many forms of economic sanction would be unlawful in theoretical terms, and yet state practice would suggest that they're not, since so many states engage in such sanctions, and there is limited objection or effective objection to those sanctions. Similarly, in human rights, there's considerable debate over the extent to which states really have human rights obligations to people within the target states outside of their territory, and what the threshold might be for triggering such obligations if they exist. And so there's considerable degree of uncertainty and debate surrounding many of these issues as a matter of international law. And some of that debate also reflects a disagreement over these issues between the global north and the global south, between the developing world and the developed world. And of course, the global south, which comprises the majority of states in the world, argue that these forms of economic sanctions, or many forms of economic sanctions, are indeed coercive, unlawful intervention, and violations of human rights. So as I conclude in my report, the debate and uncertainty leaves policymakers with some choice and latitude in deciding a state's policy on sanctions. But in my view, those choices should be guided by consideration of not only what is strictly legally possible, but also the ethical principles and values that the state identifies with, such as Canada's self-image as being a champion of the international rule of law and human rights. And we can get into in our course of our discussion as to how indeed those kinds of values and considerations ought to shape or inform policy considerations. So I'll stop there and we can dive into the details. And there are, of course, lots of details in the course of our discussion. Thank you. Clara, over to you.
Yes, please go ahead.
Thank you very much, Craig. So, thanks to the Rideau Institute for inviting me to present. So basically, my idea is to complement what Craig has just explained by introducing a political science perspective, and also by talking about the European Union as a partner of Canada in the area of sanctions imposition. Now, actually what I would like to focus on is the potential for collaboration, which is a potential that is already being realized to a larger extent than much of the public seems to realize. And basically, I would also like to highlight how there are similarities in both actors' approaches to sanctions policy. Well, first of all, both actors have quite an emphasis on human rights and the promotion of democracy in its sanctions policy. Actually, this tends to prevail over geopolitical considerations. Now, there is also a lot of overlap with the US in the idea of promoting human rights and democracy. So this is not unique to Canada and the EU. But then there are other features that seem to highlight the affinity between the policies of Canada and the European Union when it comes to sanctions policy. Well, first of all, both actors use sanctions frequently, but they are far less enthusiastic about the employment of this tool than the US is. So both follow the US in sanctions policy, but with a distance. And this distance is visible in pretty much every sanctions regime that they impose. So it's very rare, if it ever happens, that one finds a sanctions regime in which the EU and Canada are going as far as the US. So they stop way before they have reached the level of severity of US measures. Secondly, both actors, both Ottawa and Brussels, share a strong focus on humanitarian exemptions. So the idea is that within the sanctions regime, already in the legislation, there are inbuilt clauses that allow for generous exemptions in order to permit the flow of humanitarian goods, particularly food and medicine. And there is an interest in protecting the most vulnerable populations. Actually, this is already quite obvious if you take a look at the legislation. So humanitarian exemptions take up a large proportion of the legal document. And finally, and this is a highly interesting aspect, another thing that Canada and the European Union have in common is that they both oppose the extraterritorial application of US sanctions. So actually both actors have anti-boycott legislation in place, which is something that is also mentioned in the paper by Craig. So this is quite a signal delivered, or quite an important signal, quite a significant signal that both actors deliver when it comes to their positioning on sanctions, precisely because in both cases the United States is a principal ally, is a key ally in the security and the foreign policies of both actors. But this still doesn't mean that that they are ready to accept these extraterritorial effects of US legislation. So they actually have this, they have even formalized this instrument in order to protect their companies from the effects of extraterritorial application of sanctions. So a recent development that is worth highlighting here when we are talking about sanctions policy is the fairly recent adoption of legislation both by Ottawa and Brussels that will facilitate further coordination on sanctions issues. And here I'm referring to the equivalents in each of these actors to the Global Magnitsky Act of the US. So the Global Magnitsky Act that was first adopted in 2016 by the US is meant to allow for the blacklisting of individuals and also entities that are responsible for grave human rights violations and that are also involved in ground corruption schemes. So this is the peculiarity about this piece of legislation is not that it allows for the imposition of sanctions in order to respond to human rights violations, because this is something that has been very present in the sanctions policies of all actors mentioned. But the peculiarity here is that this is a horizontal sanctions list, in the sense that the listings are not connected to any specific crisis within the geographical limits of a state. But it basically has a global scope. So any actor abusing human rights anywhere in the world might end up being listed. Now, after the adoption of this global Magnitsky sanctions regime, Canada followed suit with its Justice for Victims of Corrupt Foreign Officials Act. So this was adopted shortly after, I think this was 2017. And following that, the European Union adopted just in December 2020, so just about 1 year ago, or a little bit more than 1 year ago, it's EU global human rights sanctions regime. So basically, this tool that all these three actors share allows for the designation of abusers, or basically of individuals and entities that are involved in grave human rights violations all over the world. And similar legislation exists also in the UK, and most recently it was adopted by Australia. So basically it allows for, it provides a tool to all these group of like-minded countries or like-minded entities to blacklist individuals and entities in response to grave human rights violations. So this is actually a tool that will facilitate further, or that is meant to facilitate further coordination. Well, given that we have, given the scenario or the picture of a collaboration and like-mindedness that I have depicted, it is clear that there's a lot of common ground, and there is indeed a high degree of commonality in the sanctions practices that are already in place. But at the same time, we also encounter some obstacles to collaboration. So what are these obstacles? They are not insignificant. So one of them is the fact that in the case of the European Union, the main consideration when it comes to the designation of individuals and entities is that there are very high standards to be met in terms of due process rights, which have been recognized by the Court of Justice of the European Union. And this has had an enormous impact on the framing of sanctions policies by the EU, because basically anyone who has been designated has the right to bring a case in front of the court. And if the court finds that there is insufficient evidence for the listing, or if they find that the due process rights of the individuals listed have not been respected, then they may rule in favor of the claimants. So this means that the European Union has become very cautious when it comes to designating individuals. From that point of view, it is facing a constraint that is not present certainly not in the US, and it is also not present it is equally absent in the Canadian system, where governments enjoy much more leeway when it comes to designating individuals and entities. And then a second obstacle, and this refers specifically to the equivalence to the Magnitsky Act, so the Justice for Victims of Corrupt Foreign Officials Act in Canada, and the EU global human rights sanctions regime, is the fact that corruption doesn't feature in the European legislation as a designation criterion, meaning that individuals and entities may only be designated for involvement or responsibility in severe systematic human rights violations. But involvement in grand corruption schemes is not valid. It doesn't exist as a designation criterion. So from that perspective, the equivalence of these legislation across like-minded countries may facilitate the designation of identical individuals when it comes to human rights abusers, but not when it comes to grand corruption scene. And well, I mean, the reasons why the European Union is reluctant to include grand corruption as a designation criterion is another story. But let me just finish before my 10 minutes are over with a common challenge that Canada and the EU share when it comes to justifying the sanctions policy vis-a-vis the public. Well, that challenge is that it is difficult it is not clear to the public where exactly these actors stand in sanctions imposition. Because we have a large majority of developing countries that are completely opposed to the imposition of sanctions, which decry sanctions as an imperialist tool that stands on their way to economic development. While on the other hand, we have a major ally, which is Washington, as the leader of sanctions imposition, that actually follows a policy that is much more stringent. That they have a much they pursue sanctions with much more determination, conviction, and less. Their sanctions policy is characterized by a weaker concern for the humanitarian consequences that these measures might have. So this leaves the European Union and Canada in a middle ground that is sort of trying to look for a compromise, while on the one hand, reaffirming the lawfulness of employing sanctions as part of their foreign policies, precisely in order to promote a democracy and human rights worldwide, and protect the populations of those countries whose leaderships are targeted from these undesirable policies. But on the other hand, without losing sight of the idea that major humanitarian consequences must be avoided. Okay, so this is, to my mind, this is the big common task that both actors have in front of them, designing, framing a common policy, a common public communication policy that makes it clear where they stand, where both of them stand, without fully aligning with the US approach, but without fully aligning with those denouncing the use of sanctions as always illegal under any circumstance. Thanks a lot. So back to you, Peggy.
Thank you. Thank you both very much. A lot of issues have been joined, I think, here, as well as possibilities for cooperation between Canada and the EU in this area. Craig, I want to come back to the issue, and I see it was actually our first question in the Q&A about the North-South divide, but perhaps before asking you to elaborate a little further on that, and in your view in particular, how we should view the significance of the North-South divide over the legitimacy, if I might put it that way, of economic sanctions. I wonder, or even in the course of that discussion, if you wanted to comment. I appreciate the distinction, the fact that the EU has lengthy humanitarian exemptions, and both Canada and the EU have successfully used blocking legislation. Of course, the best example is with respect to the Cuba embargo. But where the blocking legislation has manifestly failed, and we have a very current example with respect to Iran, is when the United States when it weaponizes the American dollar, excuse me, when it imposes secondary sanctions that bring in the full weight of the role of U.S. financial institutions in the global economy, we can have a 10-page humanitarian exemption, and companies will not dare risk the wrath of the United States. I'm going on a bit about this because I was actually shocked to participate very recently in a symposium involving looking at sanctions on North Korea, where senior humanitarian officials said that notwithstanding the exemptions, it was just extraordinarily difficult to get life-saving commodities into North Korea because of this intense nervousness of companies to run afoul of American secondary sanctions. So I apologize for going on at length there, but I think it touches on a big debate. But having said all that, I think looking a bit more at the North-South divide, because there are some interesting international legal implications, interpretations of law behind that too. So I turn it back to Craig, and then of course, Clara, if you want to jump in with any, I'm posing a specific question to one of you, but if you have something to say on it, just indicate that, please. Craig.
Okay, so there's a lot there, and I'll try to actually address a couple of the questions that are in the Q&A in the course of answering that. So I think it might make sense at the outset for not everyone may fully understand. I mean, we often hear this idea that, well, the United States has weaponized the dollar and the United States sanctions can be completely draconian in the extent to which they control the financial markets. But it's hard to sort of get your head around exactly how that operates. And so, and this goes to the second question about the outsourcing, so-called outsourcing of enforcement of unilateral sanctions. And so maybe just to say a few words of how financial sanctions actually work, right? So the Department of the Treasury in the United States will designate individuals or entities or entire governments as specially designated nationals, and they're put on a list. And what that does, and this refers to the outsourcing that is referred to in the question by B. Sandhu, is that it makes it a criminal offense for any American entity, that is any bank or financial entity in the United States, to process a transaction that involves that SDN, this specially designated national. Now, you can appreciate that when the United States does this, it has the effect of blocking virtually any transaction that entity would want to do anywhere in the world, precisely because financial transactions are predominantly denominated in American dollars. So if Canada passes a similar law, and it has similar laws on the books, and it designates an entity, it prohibits the Royal Bank or the Bank of Montreal from processing any transaction, that's not so hard to get around, right? If you're North Korea, you say, well, we're just not going to go through Canadian banks. But if the United States does it, there is very little ability for an entity or a government to get around that prohibition, because at some point in the process, that international chain of transactions is going to have to go through an American financial institution, because the transactions are predominantly denominated in dollars. And people will remember that the European Union, in fact, tried to create an alternative system precisely to benefit the Iranians after the Trump administration withdrew from the JCPOA, the nuclear agreement with Iran. And so Europe was trying to create an alternative financial framework in which would allow European companies to get around the prohibitions on financial transactions with Iranian entities, but so far has not been able to do so. So that's how these financial sanctions work, and they do have the effect of, if to the extent that they are really quite comprehensive, of strangling any possible financial transaction with the designated entity. So to Peggy's second point with respect to humanitarian exceptions, right? So we both, Clara and I, were speaking about the way in which there is an increasing obligation on states to impose or to insert humanitarian exceptions in sanctions regimes, so that if, for example, there's a list of prohibited trade measures against a country like Venezuela, and a list of designated entities that are going to be listed for prohibiting financial transactions. There are exceptions and exemptions for food, for medicine, for other humanitarian products and transactions that relate to those products. But the problem is, and this again goes to the second question in the Q&A about outsourcing enforcement. I think outsourcing enforcement is not quite the right way of thinking about it, but it's just the way that sanctions work is that they are laws and regulations that prohibit certain conduct on the part of private entities. And so if there's a sanctions regime that prohibits any form of transaction or any trade with entities in Venezuela, and there are carve-outs for food and medicine, there's some ambiguity there, right? And the reality is, as Peggy's indicated, that companies that are contemplating engaging in trade with Venezuela in foodstuffs or medicine are going to be consulting their lawyers and saying, is there some ambiguity here? Is there some risk that we are going to get caught up in the sanctions regime? And lawyers are very risk averse, and they're going to say, yes, there's risk. So we don't know if aspirin is going to satisfy the humanitarian exemption, so don't ship it. And so the reality is, and there's a lot of empirical research that is now supporting the idea that humanitarian exemptions and exceptions don't work very well. So Clara is quite right that Canada and the EU are much more conscious of the need for for humanitarian exceptions and build them into their regimes, much more so than the United States. But the problem is that as a practical matter, they don't work very well. And so there's still humanitarian suffering that occurs in the target states, which then brings us to the North-South divide. I'll try to be very quick on this, and we can come back to it because it's a huge issue. A number of the questions in the Q&A are addressing this. So the reality is that the Global South has, from the very beginning of the United Nations system, insisted that economic sanctions, that coercive measures that have an economic format can be seen as unlawful intervention. Indeed, there was an argument made during the drafting of the United Nations Charter that Article 2.4 of the UN Charter, which prohibits the use of force, should be understood to also include economic force. And this was proposed by Brazil. At the time, it was supported by other Latin American countries, and it was overruled and rejected in the negotiation of the UN Charter. So use of force is understood to only include military force, not economic sanctions. Notwithstanding that, the Global South has consistently since the 1980s, every year tables a resolution in the United Nations General Assembly that articulates the idea that coercive economic measures are unlawful as a matter of customary international law. Canada has supported that resolution in the past. The Human Rights Council has indicated that certain forms of economic sanctions are unlawful. So there's a large, robust objection to economic sanctions in the Global South. The Global North has tended to take the opposite view, that economic sanctions are, in fact, an alternative to the use of force and that they are a legitimate way of upholding human rights, right? But there is this view within the in the Global South that economic sanctions, as one of as the first question from Simena Jamer in the question and answers, says that this is just imperialism, right? It is neo-colonial, imperialistic imposition of power by the Global North, and it's typically countries in the Global South that are the victims of these sanctions, and that they are therefore illegitimate, and they clearly violate the principle of non-intervention as being coercive measures. And what gives that argument a lot of support lately is the developments in the realm of cyber operations. Right, so the Global North, led by the United States, has consistently said, no, economic sanctions are not coercive. We should not understand them in this way. They are lawful, they're legitimate, and so forth, even if they may rise to the level of causing humanitarian suffering in the target population, as they did in Iraq in the 1990s. But lately, countries like France, and the Netherlands, and other European countries, not to mention the United States, have taken the position that cyber operations, cyber attacks, that only have an impact on the economy if they rise to a certain level of gravity and scale and effects, will not only constitute a use of force in violation of Article 2.4 of the UN Charter, but will constitute armed attacks that would trigger the right of self-defense in Article 51 of the UN Charter. Right? So a number of countries have articulated this in formal documents outlining the position of their governments on the issue of cyber operations. Now, this creates an incredible sort of disjunct and paradox. Because on the one hand, these same countries are saying, look, economic sanctions, which may strangle the population slowly, are legitimate and lawful, and one shouldn't view this as being somehow coercive and a instance of unlawful intervention. But if you achieve the same effect more quickly with a cyber operation, we're going to consider it an armed attack, and we're going to respond in self-defense with military force. So there's a lot of people raising this question of, like, there seems to be a real disjunct here between the positions taken on cyber operations, which cause economic harm, and economic sanctions, which cause similar economic harm, albeit more slowly, right? So to put it bluntly, I can asphyxiate you slowly and that's okay. But if I do so quickly, then somehow something has changed, and we think of it as not only unlawful intervention, but a use of force and an armed attack that allows for military. So that's a very long-winded response to that set of questions. I'm happy to circle back to some of them if people want to explore details of any of those aspects.
Claire, do you want to jump in on that or open a new angle on that, or do you want me to pose a specific question to you?
Well, I'm happy either way. But basically, I can only confirm what Craig was saying. One of the advantages of targeted sanctions is that we no longer have comprehensive full embargoes like that imposed by the United Nations on Iraq during the 1990s, which had devastating consequences. And we are able to target more specifically those individuals or those elites that are responsible for the wrongdoing that we want to address. And this is actually something that both Canada and the European Union have in common, that they follow a policy of imposing targeted sanctions. Now, the thing is that, particularly with reference to the case of North Korea that you were mentioning earlier, Peggy, we actually find ourselves sometimes in situations in which the accumulation of targeted sanctions has been such over time, after waves and waves of sanctions, that the sanctions regime that ends up being formed, that results from this collection of targeted measures, it ends up being so stringent that there are only very few items that can be traded or that can be supplied to the country. So, this actually puts into question whether targeted sanctions, whether comprehensive embargoes belong to the past, and targeted sanctions have the ability to avoid humanitarian consequences, because this ability is there, but it also depends on how the senders manage them. And I think that's specifically the case of North Korea, which is definitely one of the most stringent sanctions regimes that have been put in place, even if we consider only targeted sanctions. There is also an element of what Craig was referring to. The US or the US unilateral measures, because the UN sanctions, they have already reached quite a level of severity, but in the space that is left for regular trade and regular relations with third countries, the presence of unilateral United States sanctions is very constraining. It is actually impeding some transactions that would normally be possible under the sanctions regime of the United Nations. And this is particularly enabled by the fact that the US has been focusing so much over the past couple of decades on financial sanctions. So, I mean, when we talk about the private sector being basically the actors that are in charge of implementing and these sanctions that are decided by states or by international organizations, we also have to reserve a special place to banks, because banks operate differently from trade companies. And they have much more risk aversion than regular companies trading in goods. So it's not just that some companies are unhappy about the idea of conducting trade with countries that are under sanctions, even if this trade is permitted under the sanctions regime. The problem is that very often these companies just cannot get paid, because any major bank will refuse to greenlight the transaction. So what's the point if in supplying your goods, if no bank is going to process the payment, then it's better just not to do anything about it. So yeah, I mean, altogether, this is to say that, we still have to keep this distinction between what exactly is mandated by the UN Security Council in the context of its multilateral sanctions practice, and what level of responsibility lies with states with unilateral sanctions. And very often it's not easy for the media or for the private observer to understand to what extent different senders are responsible for impacts that are not welcomed by a large portion of the international community, including active senders of sanctions like Canada or the EU. Back to you, Peggy.
Thank you. Thank you very much. Both Canada and the EU, you've both made it very clear, oppose the extraterritorial application of sanctions, unlike United States. And Craig, you noted in your report that there have been some recommendations by some studies in Canada looking at recommending that Canada, in fact, change this position. So, I'd like you to elaborate, your view on why Canada should continue with opposing this. But in that context, and I'd also be very interested to hear from Clara on this. The Magnitsky Act, in its various forms, but certainly in the Canadian form, and you discussed that in the report, has tried to avoid extraterritoriality, but there still could be arguments that it's getting rather close to the line on this. So turning it over to you, because I do believe, as someone back in the day when I was at the Department of Foreign Affairs and International Trade, if there was a law, a primary law or a list, one of them was oppose extraterritorial application of laws, of foreign laws at all costs. So I'll turn it over to you and then look to Clara.
Yes. So it's an interesting question because, Clara said that both Canada and the EU oppose extraterritorial application of law in the context of sanctions, which is exactly true when it comes to Canada and the EU objecting to and opposing American extraterritorial application of sanctions law. So Canadians will all remember, or Canadians of a certain age will remember the Helms-Burton Act, right, which caught a lot of Canadian companies within its web, and Canada passed legislation to block the operation of the Helms-Burton law. And in fact, the legislation barred Canadian courts from enforcing any judgment that was handed down in pursuant to the Helms-Burton law. And it's not so ancient history because the Trump administration actually resurrected certain aspects of the Helms-Burton law and sought to enforce the Helms-Burton law, which continued to, of course, be on the books for that entire time, but it resurrected the application of the Helms-Burton law. And Canada responded immediately. And if you look at the Canadian government website, there is a page devoted to how to respond to the Helms-Burton law resurrection by the Trump administration. it's not so clear that Canada objects to its own application of law extraterritorially, right? So when I was doing the research on Canadian legislation, it strikes me that it's possible for some aspects of the Canadian legislation to be applied extraterritorially, right? So it's my understanding that Canada has not done so, right? And so there's been no effort to apply the Canadian legislation extraterritorially or to implement or enforce Canadian laws extraterritorially. But just to pause there and note, and I note this in the report, that it's quite a complicated question as to whether a law is indeed being applied extraterritorially. So to take the American example again, I mean, if the American legislation prohibits any financial transaction with some designated, not a German company that is purporting to do business with Iran, of course it is affecting and prohibiting, in a sense, conduct that is occurring in Europe or between a German company and Iran, and that is entirely outside of the territory of the United States. But the application of the law, in some sense, is within the territory and certainly within the jurisdiction of the United States. It's prohibiting an American bank from processing a transaction in the United States relating to that conduct between a German company and Iran. So is it really extraterritorial? I mean, lawyers would have a lot to say on both sides of that argument as to whether it really is extraterritorial application of law. And Peggy, as you point out, I mean, the Magnitsky laws are designed to force oligarchs in Russia, in the first instance, to try to exert pressure on the Russian government. So it's clearly designed to affect people outside of the territory and outside of the jurisdiction of Canada, for conduct that is outside of the territory of Canada. So is it extraterritorial? Again, the focus of the law is prohibiting Canadian nationals or residents of Canada from dealing with those people. So arguably it's not extraterritorial in its application. But to come to the real thrust of your question, there are these reports and some scholarly writing in Canada that says, perhaps Canada should expand the extraterritorial application of its sanctions law. And I think what is animating those recommendations or these ideas is that, again, it's coming from the perspective that sanctions are an effective tool for championing human rights, for enforcing human rights, and enforcing sort of democratic and rule of law norms. But I think that they ignore the public international law prohibition on the extraterritorial exercise of jurisdiction. And I think that one has to be really very cautious not to violate those norms, or they're not just norms, they're principles of international law. And I think that this is where sanctions law gets tricky. You end up being sort of hoist on your own petard if you are violating international law in the course of trying to enforce international law. And so this is why in my report, I suggest that actually I think Canada and the European Union are on much safer ground in avoiding secondary sanctions, not engaging in the extraterritorial application of their law in the course of implementing sanctions law. And my sort of instinct would be to remain on side with the principles against extraterritorial application of law or exercise of jurisdiction, and that we should avoid and resist following the United States in imposing secondary sanctions. Clara?
Thank you. And Clara, before turning to you, I wonder if you can just add into the mix in your response. I mean, one of the very interesting things about the European Union, as opposed to other regional organizations, and of course the report, Craig's report points this out, is that other regional organizations have not looked at imposing sanctions on non-members. They have taken the most solid legal ground of constitutionally for giving itself, the organization, the African Union is an example, the power, and all the members of the African Union agreeing to that, the power to sanction its own members. And frankly, as an organization that is, the Rideau Institute has long tried to argue that Canada would be much better placed promoting human rights if we would first focus very much on our own practice and ensure, and of course the obvious example here is arms exports to Saudi Arabia, denounced by the UN Human Rights Expert Group. So with that in mind, the EU has decided not to impose sanctions on its own members, through this type of regime. So anyway, I'll stop there, just ask you to comment on that and any other aspect of this discussion that you want to.
I think that this is quite an interesting point. Why is the European Union known for imposing sanctions externally, but not internally? Well, actually, the European Union also has an article in its own constitutional treaty. Well, basically, in the Treaty of Lisbon, which is the Treaty of European Union, it has a clause that allows for the suspension of members when they deviate from certain standards of rule of law and protection of democracy and separation of powers internally. So the tool exists, and it has been in place since the creation of the European Union, properly speaking, in 1992. This is called Article 7, so everyone can Google it if you're interested in the wording. Now, the thing is that there has not been any full application yet. And there has been talk already for several years about the possible activation of this article, particularly with reference to Hungary, which has been witnessing a recession in terms of independence of the judiciary and democratic standards and rule of law. So there has been talk about activating this. And it has also been put on the table with respect to similar deficiencies in Poland. Now, if we compare strictly, but it hasn't fully prospered yet. So we haven't witnessed any single case of suspension. So in any case, if we compare the kind of violations that the African Union has been witnessing, where there have been fully fledged coup d'etats, and sometimes accompanied by violence, it's not the same level of severity than what we have witnessed in Europe. So, but in any case, this possibility is foreseen in the EU, just in the same way that it is foreseen in the African Union or in a number of Latin American organizations, or also ECOWAS, which is probably the organization that has been making a most profuse use of this suspension clause. And probably what makes the activation of this suspension most interesting is the fact that even though it is a sanction, because from the point of view of sanctions typology, we can consider it to be a diplomatic sanction, an internal diplomatic sanction, which normally doesn't have economic implications. So this means that it doesn't catch too much attention from the media, or attention. It doesn't catch too much attention from researchers in economics. But in any case, what is interesting about the activation of this tool is that it shows how these organizations conceive of sanctions in quite a different way than we do. Because these suspensions, they tend to be accompanied almost invariably by mediation missions, in which an African leader, accompanied by other leaders from other member states of the organization, try to they are dispatched to the country, and they negotiate and mediate and try to reach an agreement that guarantees a restoration of the constitutional order in these countries. So it's not sanctions in the sense of just putting economic pressure and waiting for the target to come crawling, asking for the sanctions to be lifted and for normal trade links to be restored so that the previous level of wealth is restored too. But it's really an instrument that is meant to be temporary and that is always accompanied by quite powerful tools of mediation. So all this sets the use of sanctions apart from what we conceive as use of sanctions. And to my mind, it's actually quite an inspiring practice. This is perhaps something that we could also contemplate, or I mean, at least we should start asking this question. So other than sanctions, what else is being done in order to resolve the situation? Are there talks going on? And what sort of agreement is being proposed, and how fair is that agreement? To what extent does it contemplate or take into account the interest of all sides? So perhaps there's actually something to be learned from this practice that has been initiated by these organizations in the developing world. But I mean, coming to the practice of the European Union, which is actually my topic. Well, I mean, the reason why while the member states started to impose sanctions together has also a legal foundation. I mean, there were two factors that played a role here. First of all, was the fact that the US was the main ally of European countries during the post-Cold War, during the Cold War period. And the US was interested in imposing sanctions against third countries, and they also wanted to have Washington also wanted to have its European allies on board. So this sanctions practice started as a way of accompanying or supporting Washington policies. This goes back to the 1980s, but even before that. The reason why European countries decided to start imposing sanctions together had something to do with the United Nations Security Council practice. So when they imposed sanctions on Rhodesia, the member states of the then European community, they decided to adopt national legislation rather than common legislation, because they felt that they were obliged to implement UN Security Council mandates on their own. So they felt that this was an obligation of the member states and not an obligation of the European community as such. But then they were dissatisfied with the outcome, because every country was imposing different measures. So they were not implementing uniformly the mandate by the UN Security Council. And also the timing differed. So that this created a situation of uncertainty for economic operators. So on the basis of this patchwork of legislation implementing UN sanctions, they decided that for the common market, it was going to work better if legislation could be adopted at the European level and be valid for every economic operator in the entire territory of the common market. So this is how they started to implement UN sanctions jointly. And then when in the early 80s, Washington started to encourage them to impose sanctions in order to support Washington's policies, then they decided to continue with this practice as a joint practice. So now both the implementation of UN sanctions and the implementation of autonomous European Union sanctions, they look the same. They use exactly the same legislation and they have the same validity for the purpose of the common market. So this is how it came about. So interestingly, even though I'm not a lawyer, I have to highlight that there was a legal. Well, I mean, there was basically a legal or a UN origin to this common practice, which has now developed into a very vast and very active sanctions policy, because basically the most recent analysis using quantitative data highlight that the European Union is one of the main sanctions senders worldwide. If not the second, it comes very close to being the second. I mean, it doesn't reach the same level as the US, but I mean, if we look at the recorded, if we look at the records or the recorded practice, it is definitely one of the leading actors, if not the second actor. Okay, so I think I've spoken long enough. Back to you, Peggy.
Thank you very much. I'm conscious that we still have some questions in the chat that we haven't gotten to, but I also want to leave some time. So maybe I'll just warn you that I'd like to come back at the end, Craig, to your comment about Canada not just looking at the narrow sort of legality, although, as you point out, that's terribly unsettled, of the when considering implementing sanctions. And of course, this question really, applies to the EU as well. But that both Canada and the EU should also be influenced by broader legal and ethical questions and values. We've discussed some of those. The concern about imperialism, the tremendous humanitarian impact, practicing what you preach, and so on. So I'd like to come back to you, both of you, on that. But first, I'd like to go to, if we can just maybe move through the questions quickly. My good friend Robin Collins, I think what I'm going to say on that one, people can read, debate about just how devastating the comprehensive, essentially the comprehensive embargo on Iraq was after its invasion of Kuwait. I mean, this is discussed, and there are lots of footnotes in the report noting the debate over the scope of the humanitarian impact. But I would say that the weight of opinion is that the scope of the impact was pretty devastating, and there's a broad view now that, and Clara has talked about this in particular, the evolution away from these total embargoes. Obviously, if either of you want to comment on that, but I'm going to abuse my role as chair and make that comment. Craig, were you putting yes, Craig wants to comment further on that, please.
So I just thought that a couple of questions, beginning with Robin's, I think touches on sort of the role of the United Nations, and it gets to the last comments that Clara was making about the European Union and what distinguishes the European Union from other international and regional organizations. And so I just want to make it very clear for some in the audience who may not fully appreciate the structure of the UN Charter, and this is what Jane Bolden is getting at in her comment in the question and answers, is that the UN Charter provides the UN Security Council with clear authority to impose sanctions, right? So there's no question that the UN Security Council has this authority, right? Once it establishes that there's a threat to international peace and security under Article 39 of the Charter, it can, under Article 41, authorize member states to impose economic sanctions. And the combination of Articles 25 and 103 of the UN Charter make the UN Security Council orders in the form of resolutions superior to other international law obligations that member states might have. So to the extent that the UN Security Council resolution is in conflict with some other obligation that the state has, other than a jus cogens norm, a peremptory norm of international law, and arguably certain human rights obligations are peremptory norms, then states not only are authorized, but are obliged to follow the UN Security Council's authority. So that's not what is really at issue here. The question here that we're really getting into, for the most part, now there are questions about certain UN Security Council resolutions and the extent to which they themselves may violate international law. But the really tricky issue is when states like the United States, as the prime example, impose sanctions without this UN Security Council authority. And the unique aspect of international regional organizations is that they tend to limit themselves to imposing sanctions on member states, that is, states that are members of that regional organization. So the Organization of American States may impose sanctions on one of its member states. The authority for that flows from the treaty that creates that organization itself. Where the European Union is somewhat unique is that it is willing to and does impose sanctions that are not UN Security Council authorized and are not against a member state, but are against some country that is outside of the European Union. And then the European Union is effectively, even though it's an international organization, is imposing sanctions without international law authority. So they're very much in the same position as the United States, imposing sanctions unilaterally or autonomously. So that, I think, gets at some of the questions that were posed in the Q&A as to, are sanctions not sometimes justifiable and authorized and legitimate? The short answer to that is yes, when the UN Security Council is authorizing it, although, as I said, even then they can run into problems. So I'll stop there, Peggy, and return it to you to go through some of the Q&A.
Okay, well, yes, I think you've touched on some, and also, as you said, on Robin's question. I mean, there's an overarching question on geopolitics, which is from John Foster. Could the panelists comment on the geopolitics? I agree the recent sanctions emanate from Washington, with Ottawa, Brussels, London jumping to obey. They are leveled on disobedient countries: Iran, Syria, Venezuela, China, Russia. They are about power, economic warfare, and attempted regime change. Your views, please. So that's quite the question, but it's on, no doubt, in the back of many minds. So do you want to start, Clara, with that one, or please?
Well, I don't think that there is any question that these tools have a geopolitical dimension to them. That's pretty clear. So, I mean, it's not just about trying to promote human rights and democracy, but there is also, I mean, imposing sanctions is also a way of positioning oneself in the context of a geopolitical dispute. So I think that one example in which one of the parties to a dispute has managed to mobilize a substantial portion of the world community in favor of its cause has been South Korea. So South Korea has actually obtained not only the support of the United States, but pretty much of everybody else. So supporting the sanctions against North Korea are also a way of positioning oneself in favor of the US and South Korea in a geopolitical dispute about, well, what should be the future of the Korean Peninsula. If there should be one reunification at some point in future, which system should be present? Which system should rule the Korean Peninsula? This is, imposing joining the sanctions of one of the parties to the dispute is a way of ideologically and politically positioning oneself in favor of one of the parties and against the other party, as opposed of just keeping some neutrality or sort of accepting that, look, whatever happens on the Korean Peninsula is not our problem. And actually, we have very little trade with particularly with North Korea. So there's no point in stopping trade because it's not going to have any influence. So this could have been, at least from a European point of view, a defensible attitude. But this has not been the policy choice made by the EU. The EU has actually not only implemented the sanctions imposed by the UN Security Council, but it has associated itself with South Korea as a privileged partner, also in terms of trade, well, both politically and economically, a privileged partner of the EU. And it is also siding with the US and Canada and everybody else that supports South Korea and decries the policies of North Korea, not only vis-a-vis Japan and other neighbors, but also vis-a-vis its own population. So it is undeniable that there is a geopolitically relevant exercise of positioning linked to any sanctions exercise.
Thank you very much. Craig, did you want to jump in there or wait for another question?
Sure. I mean, I'll try to be very brief, but I think that one of the issues that question gets to is also I think the question that Robin Collins was getting at in hers, and she's sort of clarified later in the Q&A, is that it really gets to the question of objective, right? Like, what are the objectives of sanctions? Sanctions tend to be a very blunt instrument, and they're made worse by the fact that governments are often very unclear in their articulation of what the strategic or policy objective of the sanctions are. Now, it's not really much of a secret that one of the objectives of the U.S. sanctions regime on Venezuela is to effect regime change. Well, that arguably is not a legitimate objective for sanctions. And this is precisely why those in the global South say that economic sanctions are a form of unlawful intervention, coercive intervention in the domestic affairs of states. So, one of the things that I think policymakers should take seriously is that if one is going to impose sanctions, presumably, and in the case of Canada, for the purposes of enforcing compliance with human rights obligations, that has to be made very clear. And there has to be, to Clara's point earlier about public messaging, an explanation of exactly how it is that one sees that the sanctions are going to achieve that objective, and maybe provide sort of metrics on how we might measure that. Another problem with sanctions is that they're often left in place for a very long time. So I think, Robin Collins's point is that one has to distinguish between sanctions that were authorized by the UN Security Council under Article 41 of the UN Charter to force, as an initial measure, to force Iraq to withdraw from Kuwait after the invasion of Kuwait in 1990, from the continuation of sanctions long after Iraq had left Kuwait, and were now presumably for objectives that had nothing to do with the initial act of aggression, but had to do with keeping Saddam Hussein in the box and possibly even causing regime change in Iraq, right? So I'll leave it there, but this is one of the problems is articulating clear objectives.
Thank you. Yes, thank you very much. And I might just note in passing, because we're not going to really be able to get into this discussion much, but the report does indicate that there is a large literature on the question of the effectiveness of sanctions, and some indication that they're not that effective. And so that obviously is an issue that would factor into the debate. And I might just note with respect to North Korea that when I was discussing the humanitarian impact of the sanctions regime, as Clara noted, one of the most toughest, most comprehensive of the UN regimes, it was the embassy of South Korea in Ottawa that was sponsoring the panel that was looking at the impacts, and in particular on the humanitarian impacts. Looking here at the further questions, there's one that's very specifically put for you, Clara. Thank you for all the information. I find the issue of the legitimacy of EU unilateral sanctions quite confusing. The question is very huge. Maybe how do you define it, assess it, approach it scientifically? Maybe define it. That would be a start.
Okay. Well, I think that this is not really a scientific question. It's more of a political question. So why do certain actors like the EU want to defend the lawfulness of a unilateral sanctions practice, but then at the same time contest certain unilateral practices, such as the extraterritorial effect of U.S. sanctions. So I think that there is sovereignty and a legal aspect to that. So basically, the difference between both sanctions practices, let's say that the position of the EU is really defined by legal aspects that are very accessibly elaborated in the report by Craig. So first of all, in terms of legal justification, or in legal terms, it is not established that unilateral sanctions are unlawful. So the understanding of the EU is that it is entitled to impose sanctions. In other words, nobody is obliged. No sovereign entity can be obliged to continue trade with any partner if it doesn't want to. So that's the departing point. There are limits to that, and these limits are also defined under international law. Causing widespread starvation, causing a famine, would be contrary to international law. So this is something that the EU doesn't want to be responsible for. So it designs its sanctions in such a way that they can exert noticeable pressure on the targets, and they also understand that society is going to be affected in one way or the other. But this pressure may never reach catastrophic proportions. It might never put in danger the survival of the population. So this is why you have such care taken of humanitarian exemptions, and something that I have not mentioned before, but it's actually also part of EU sanctions policy, humanitarian aid continues. So humanitarian aid does not stop when sanctions are imposed. And actually, in the case of Zimbabwe, not many people know that, but while Zimbabwe was under sanctions by the EU, because the economic crisis intensified, the EU stepped up its humanitarian aid to the country. So you have a situation that might look pretty contradictory on first inspection. The EU imposing sanctions on Zimbabwe and at the same time increasing the amount of aid that it was giving to the country in order to mitigate the humanitarian crisis. So let's say that this from the point of view of the EU, there are really legal limits as to how and when and to what extent sanctions can be employed. If you look at the legal regulation, this makes perfect sense. So if you look at it from other angles, perhaps it's not clear why they follow this policy. And then again, on the extraterritorial effects, the understanding of the EU is that the member states, and basically the EU is responsible for regulating the activity of economic operators, because they have this common market that belongs to, that is made up of the economies of the member states, and they have all delegated power to the European Union to manage that market. So basically, it belongs to the sphere of sovereignty of these countries that operate under the European Union to decide what economic operators may or may not do. Sanctions with extraterritorial effects interfere with that sovereignty, because basically you have a third actor making a decision as to what these operators may or may not do in respect to other actors. So this has much more to do with the notion of sovereignty and the authority, basically the exclusive authority that the European Union has over the governance of the common market. That is not, extraterritorial effects of third country sanctions interfere with this exercise of sovereignty. So on the one hand, we have some constraints that exist from the point of view of protection of populations, or this humanitarian concern that is quite strong in the sanctions policy of the EU, and that has also a legal foundation. And then you have the concept of sovereignty. So if you put these three elements together, you actually see the contours of the sanctions policy of the European Union. So that's basically where they stand. Now the question is, the thing is that it's not easy for the public to understand that if nobody explains this clearly. And this is precisely where I saw a point of convergence between Canada and the EU, because they do not take the same extreme position on sanctions that we are accustomed to see as far as Washington's policies are concerned. But then we do not share the developing countries' rejection of all possible sanctions under all circumstances. And this is precise. I mean, the fact that this question has been posed in this framework confirms that some better communication needs to be done in order for this position to be better understood.
Thank you very much for that. And since the report around which this discussion centers is legal and policy implications for Canada in particular, I wonder, Craig, if I could just ask you, we're a little over here, but we've still got a strong participation from our audience. I wonder if you could just comment on all of this discussion we've had on the unsettled areas of the law, on the humanitarian impact, on the effectiveness. What would you say are the key policy implications of all of this, of your report, for Canada when considering using economic sanctions as a foreign policy tool?
Thanks. So before I answer that question, I'll just take 20 seconds because I see like 4 people now I think have chimed in on what about climate change? And so you may be interested to know that I actually started doing this research on economic sanctions precisely because I was interested in that precise question. I've done some research on the extent to which the consequences of the climate change crisis are likely to put pressure on what's called the jus ad bellum regime, or the regime that governs the use of force in international law, and suggesting that as the consequences of climate change become more severe, they're going to be viewed as a national security threat, and countries are going to begin arguing for potentially the threat or use of force against what I call climate rogue states, countries that would, for example, burn down the Amazon. If it came to that, would countries intervene, potentially even militarily, which seems like a crazy idea now, but 20 years from now may not seem so crazy. And of course, before you get to these forces, as Robin Collins has pointed out, you typically resort to sanctions under Article 41 of the Charter. And so this question of whether, in fact, the UN Security Council might, or countries would otherwise unilaterally or autonomously impose sanctions against so-called climate rogue states, that is, states that are flagrantly violating their international law obligations under the international climate change regime, is entirely plausible to me. The UN Security Council has identified such things as the Ebola pandemic in Central Africa, in the Congo, in 2014 as a threat to international peace and security, and therefore triggered its authority under Article 41 and 42 of the Charter. And so it's not that impossible to contemplate the UN Security Council imposing sanctions against climate rogue states, or in the event that was blocked, for countries to take unilateral sanctions. As someone noted in the chat, that would, of course, put Canada in something of a bind because Canada is falling down on its climate change obligations, as is Australia, right? So and depending on how you measure these things, some of the global north would all of a sudden be potentially in the crosshairs of economic sanctions. So, which brings me to Peggy's question of where does this all lead for policymakers in Canada? I mean, as I conclude in the report, I think that the bottom line is that a number of the legal regimes that govern this area are somewhat unsettled, and there are increasing debates over, as I said, the issue of intervention, for example, being unsettled even further by developments in cyber law and the response to cyber operations. And so that uncertainty leaves policymakers with a considerable amount of discretion or choice. And one intuition might be to push the envelope to use economic sanctions to the maximum that one can, precisely because there seems to be uncertainty as to what is exactly permissible and what isn't. But I caution in the report, and I think I continue to believe that policymakers arguably should move in the opposite direction and take that uncertainty as a reason for caution, and that this is precisely why they should be making decisions informed by the legal, ethical values that inform the legal system itself, right? So Canada considers itself a champion of human rights, of the international rule of law, of constitutional democracy. And so while, as I said earlier, the impetus for sanctions is often to enforce precisely those things, is to champion human rights, to champion the international rule of law, Canada has to be cognizant of the argument that, in fact, in engaging in some of these unilateral or autonomous sanctions regimes, they may be violating international human rights obligations, at least in the eyes of many, that they may be engaging in what the Global South considers to be unlawful intervention, coercive intervention in the domestic affairs of states, and that therefore there is something of a paradox here, and policymakers need to be cautious and cognizant of that paradox in framing their policy. And again, getting to some of the questions in the chat, one also has to be really informed by the extra legal considerations, like how effective are these? I mean, are they achieving the objective? When you look at the cost-benefit analysis, I mean, the harms that you're causing with sanctions, are you really achieving the objectives that you're seeking to achieve? Are the benefits really outweighing the costs in this regard? So we could go on for another half hour on that issue alone, but I'll leave it there. Peggy, thank you very much.
Thank you both, Craig Martin and Clara Portela, for just a wonderful discussion. I mean, there are so many issues here. I hope a lot of them have been elucidated a bit more for the audience. I really regret we couldn't get to all of the excellent questions that the audience has posed, and that suggests to me that we might want a more focused follow-up to this webinar. I also want to take a moment to thank the Rideau Institute office manager, Sarah Bowles, and our new intern, Alex Rizcala from the University of Montreal, for all of the tremendous work they did in getting the word out with respect to this webinar. And once again, I thank the audience very much for your engagement, your questions. And with that, I will wish everyone a very good day. Thank you.
Thank you.